So let's dive into today's episode of Washington in Focus Daily. So Let's Go Washington announced on Thursday they are suing Secretary of State Steve Hobbs over his decision to block a public vote on the new state law, the new millionaires tax. The Political Action Committee, LGW, claims that Hobbs has misquoted the Constitution in his denial of the request to let voters weigh in. And much of the argument centers around the emergency clause in the bill's language that blocks any potential referendum on it. Lawmakers attach these clauses when they feel it's an emergency. Without this, the whole state budget's going to fall apart. We can't keep, state agencies operating, and so they attach this clause and essentially makes those bills referendum proof. They've been doing that a whole heck of a lot more in the last couple of years. In fact, I think during the 2025 session, we had close to, was it 200 or 400 bills? Really, it was that high that had the clause attached. It was a record, and I think we came close to that in the 2026 legislative session. So here is part of my conversation with Let's Go Washington's founder, Brian Heywood, earlier this morning.
This sounds like we're really getting into the weeds, and aren't you playing with words? But in legal documents and in constitutional documents, the commas and the or fors matter and have enormous changes in what they mean. And in this particular case, because it says it has to be, this is basically giving the legislature a get out of jail free card to say, sorry, voters, this is something that's so important, you don't get to have a say. Wow. And it was designed this is really literally what a check and a balance is. It's designed to give the legislature a tool when there's an emergency, an immediate need for it, necessary for the immediate preservation of public peace, health and safety, support of the state government. When it's necessary for those things, then they can have an emergency clause and they can prevent a referendum on the law. However, what they've done is they've said, or for, which means basically either it's immediate or we need it for the state government, right? If you just support of the state government, if that's your criteria, pretty much everything that the legislature does is for the support of the state government. And so it means that it completely eliminates any check on the government. And they've like the most telling thing to me is that this is what the Secretary of State wrote to us, right? Necessary or for the support of the state government. The legislature has taken this stance. This is their interpretation. It's the stance that they've taken. I think they've tried a couple of times. There's been some court cases around this, but they're just basically saying, hey, we don't think anyone can challenge us on this. And so our first step here is to challenge them on this very doctrine itself.
So Heywood and Let's Go Washington argue that the clause is invalid, and they plan again to bring this issue to the state Supreme Court to clarify the limits of the clause in hopes of allowing a public vote. There's a real urgency here, because if indeed somehow a referendum at this point is allowed to move forward, there's a very short window of gathering signatures. In fact, the deadline being June 10th, where they would have to have 200,000 signatures. So that is a very short window, something that Heywood believes is doable because of the public resistance to the income tax, at least based on polling that we have seen. So he's going after the Secretary of State over the referendum denial and challenging how Hobbs has interpreted the constitutional language. At the same time, Let's Go Washington is preparing 2 initiative campaigns to repeal the income tax. And Heywood told me it's a lot easier and simpler for voters to understand a referendum, so it is worth this fight while they also work on the initiatives.
A referendum is up or down, do you support this law? So it's an easier thing for voters to vote on. And the legislature knows that. They know that a referendum, it's easier to get a no than it is to get a yes on a referendum, on any initiative, right? So with the initiative, I remember we were saying, vote yes, pay less, because that's the message that we have to get people to understand. Oh, you have to vote yes to get rid of an income tax. With a referendum, it says, should this law be upheld? No, get rid of that law, right? It's easier to get a no. And so that's an important thing as part of the process. And then the third thing on the referendum is that there's no financial impact statement that goes on a referendum. You just either support the law or you reject the law, and it goes away. And it doesn't give the attorney general the opportunity to propagandize on the ballot itself. So there's a lot of reasons that a referendum is important and valuable, and asking the Supreme Court to uphold this constitutional safeguard is not a fool's errand. But then we go to the people versus the legislature. If we do initiative to the people, we have to gather 400,000 signatures now between now and July 3rd. And then it would go on the ballot in November. So there's a short time frame, but if people remember, we got 540,000 signatures to stop the natural gas ban in about 45 days.
It's important to note that if it comes down to this repeal attempt being by initiative and the referendum is a no go, um, there would be an initiative that would go directly to the people as well as one to the legislature. Now, assuming the one that goes directly to voters, and it would be this year, the November ballot, um, and assuming it's approved and the income tax is in fact repealed, it would stick for at least 2 years before lawmakers could start messing with an attempt to undo it again. When voters pass an initiative that goes directly to the people, lawmakers cannot undo that for at least 2 years. Whereas if an initiative to the legislature is approved, lawmakers can come back the very next year and undo it. Now, recall the parental rights initiative in not so distant history. They did that. It was adopted. The initiative went to the legislature. It was adopted by lawmakers almost unanimously, as I recall, only so they could come back then the next year, and House Bill 1296 was then approved, which basically repealed and some suggest even went further than the initial undoing of the parental rights law. So they did that in 1 year. So my point is, if in fact voters approve an initiative that goes directly to you on the ballot in November, lawmakers won't have next legislative session. They would have to wait 2 full years before they could come back and attempt any kind of a change. And remember, we have 2 initiatives already on the ballot this November. One is, in fact, to restore parental rights, and the other is to protect girls in sports and keep biological males out of women's sports and also out of locker rooms and bathrooms. This has been a huge fight. Based on the most recent polling I've seen, it seems voters are inclined to approve both of those measures. But in addition to that, it is likely at this point we're also going to have an attempt to repeal the recently passed, signed into law income tax on our November ballot. It's going to be a crowded ballot. And then one more thing on the income tax. Cadiff and former AG Rob McKenna are also planning a legal challenge, pulling together plaintiffs and determining which court venue they're going to file in. So there is a lot to keep track of on that front. Likely going to be the early part of next week before anything is filed along, on that Cadiff challenge and former AG Rob McKenna.